Be seated. State of Ohio versus Cody McDonald at the Lawrence County Jail. All right, Mr. McDonald, can you hear me?
Yes, sir.
All right, this is State of Ohio versus Cody McDonald, CRB 25-190, CRB 13-338, CRB 12-1113. It looks like, well, here, this was originally at one point Mr. Morford's case. I think it still is. Mr. Morford, this is Cody McDonald. Looks like it's alleged that he's failed to appear on August 4th for a review hearing. All right, well, I guess it really isn't your case anymore, Mr. Morford, so sorry.
Okay.
But, all right, Mr. McDonald, do you admit or deny that you failed to appear for your review hearing?
Yeah, I did.
All right, do you have a good reason why you weren't here for your review?
No, Your Honor.
All right, when did you get picked up?
The 30th,
All right.
September 30th.
All right. Now, finding contempt on that, it'll be 3 days jail. I'll give you credit for 3 days. And you still owe some fines. It's like $250 on one and $235 on another. I'm going to set you a new review date, but I'm not going to go out too far on it because where you didn't appear.
Okay.
So I'm going to set you back on October 17th.
Okay.
That'll be a review at 9 a.m. Now, if you don't appear again, Mr. McDonald, you'll get another warrant. You'll eventually get picked back up and you'll end up spending more time in jail. And if you just show up, you can work your fines off in community service. If you don't have the money to pay them. Matter of fact, if you want to work some of them off the next 2 Saturdays in a row, tomorrow and then the following Saturday, after you be here at 7:30, you'll get double credit. So you get essentially $50 per day knocked off, which turns into double credit to $100 a day. So you can almost in 2 days knock out one of your cases.
Okay.
Okay?
7:30 tomorrow morning?
7:30 tomorrow morning here at the court.
Okay.
All right, so I'll see you back October 17th at 9 a.m.
Am I getting out today?
You should be released today.
Okay. Thank you, Your Honor.
All right, thank you. State of Ohio versus Rodney Spears, case number CRA 25-498, and Hunter Cooley is on deck. All right, this is state, well, we could get in now. Yeah, he's not on yet, so give him a sec.
Pick them up today.
Yeah. Yep. No problem at all.
Defendant or prosecutor.
Your Honor.
All right, Mr. Spears, can you hear me?
Yeah, absolutely.
All right, this is State of Ohio versus Rodney Spears. CRA 25-498, it's Mr. Stratton's case, and we are here because it's alleged that on or about September 29th that Mr. Spears failed to appear for a pretrial. Mr. Stratton.
Your Honor, he has. There's been some issues that we just need to address. He's willing to go inpatient at TCC. detox first.
Yep, that's correct.
So I asked that he be released to detox. We spoke about this case in the back, and we just need to reset this case.
Okay. Mr. Spears, your attorney is indicating that you're willing to go into inpatient treatment. Is that correct?
Yeah, I requested.
Okay. So you're going to detox first. So initially, when I first looked at this file, my intentions was to revoke your bond and set you a higher bond. But the fact that you're willing to go into treatment, I'm going to give you at least a little bit of the benefit of the doubt. Now, I'll tell you this, Mr. Spears. If you leave treatment or you run from treatment, Mr. Sowards is still on your bond. He will come get you, and I promise you, you're going to get a bond that you will not likely be able to make. Have I made myself clear?
Yes, sir.
All right, so I will recall the warrant. I'll continue the bond, but with a stipulation on it that he's to only be released from jail to counseling center. And Mr. Stratton, when do you want to come back?
Sometime in October, Your Honor, except the 6th and the 13th.
Well, 13th is a holiday.
Okay. For this means.
Are you here the 20th?
Yeah, I can do 20.
All right, I'm going to set you back on 10:20 for preliminary hearing.
Now, is he to be detoxed at the jail, or is he to be released to?
You guys are doing the detox, correct?
Yes, that's correct.
Okay. PCC is doing the detox.
Okay. But there's a possession charge. When are we coming back on that, Your Honor?
October 20th. Actually, can we recall this? Let's recall this case back again. We need him back out. Mr. Spears.
We call it now?
Yeah. Mr. Spears, are you there still? Can you hear me? All right. Well, it looks like Mr. Sowards is requested to be released from the bond at this point.
Well, Your Honor, we have no objection to that, and the court just allowed him to sign his own bond, or maybe even put an ankle monitor on him at TCC.
Mr. Hill, any thoughts?
The charge is an aggravated possession. He didn't show up on September 29th, and I guess he's been arrested since then. So if he were to go back to treatment, which we're not opposed to that, but we believe, I think the GPS monitor is a good idea.
You know if we have one, Mr. Cooper?
I can check.
Okay, well, what I'll do is I'll release Mr. Sowards from the bond. I'll set an OR bond at 5,000 OR, GPS monitoring, and only release to TCC, to the counseling center. So what that means, Mr. Spears, is you're going to be on an ankle monitor. Mr. Sowards is requested to be off the bond, and I'm granting that. However, if there's not an ankle monitor available, you're just going to have to sit in jail until there's an ankle monitor. But once there is an ankle monitor available, the counseling center can come pick you up. Now, I'm going to caution you on something. I've already cautioned you about leaving treatment, but I'm going to caution you even more now with an ankle monitor. If you tamper with the monitor or cut the monitor, our common pleas judges take that very seriously. It's a third-degree felony, and they typically send people to prison for 3 years for that, for the entire time. For this. So if you think about doing anything at all, think about this. Don't tamper with or cut the monitor, okay? Just when I see you nod your head, I want just that.
Yes, I've had it.
I just want to make sure that you are fully aware of that, so
Yeah.
that'll be the order of the court.
State of Ohio versus Hunter Tooley, case number CRB 24-385 A and B, CRB 24-329, CRA 24-328, CRB 24-292, CRB 23-147. David Frazier's on deck.
All right, Mr. Tooley, can you hear me? All right, this is State of Ohio versus Hunter Tooley, CRB 24-385 A and B, CRB 24-329, CRA 24-328, CRB 24-292, CRB 23-147. All right. It looks like this was originally Mr. Morford's case.
Yes, Your Honor.
It looks like it's been sentenced on all of that. hasn't it?
What's the last case? I don't remember yet.
Let's go ahead and share it here.
2885 has not been sentenced on, Your Honor.
Okay. Looks like the others he has, I think. Maybe. Maybe not.
And he hasn't been sentenced on the 23-147 either. He's been sentenced on any of them,
All right, Mr. Tooley, it looks like you haven't been, all your cases are still pending here on this, but it looks like on April 14th of this year, it's alleged that you failed to appear for a pretrial in these matters. You admit or deny that you failed to appear?
Sir.
I'm sorry, can you say that again?
Yes, sir. Yeah, I didn't appear.
Okay, do you have a good reason why you didn't appear?
No, sir. Just last.
All right, well, here's what I'm looking at doing. When did you get picked up?
Whenever you're ready.
Yes.
2 days ago. 2 days. Yeah, 2 days ago.
If I were to have you screened today, would you test positive for anything?
Marijuana, that's it.
That's it.
That's it.
All right, so I'm gonna make a deal with you here. If you're honest with me now
Yeah.
about what's in your system, then when I screen you, you'll get a pretty favorable bond. Something that I think it'll be benefit to you. But if you're not being honest with me, and it comes back with other things in there, you may not leave jail. So I'll give you.
Yes, sir.
Okay.
Still want me marijuana.
All right. So want to have him screened, and then we'll have him back out here shortly.
Yes, sir.
State of Ohio versus David Frazier, case number CRA 25-619, CRA 25-621, and Jason Ferguson is on deck.
All right, Mr. Frazier, can you hear me? Mr. Frazier, can you hear me?
Yes, sir.
All right. Mr. Frazier, we're going to go through your cases with you. These are felony cases, so I can't take a plea from you, but you have the following rights before the court. You have the right to remain silent. We're recording everything, and if you say something that is against your interest, the state of Ohio can use it against you. You have the right to an attorney. If you can't afford an attorney, I can appoint an attorney to represent you at no cost. You have the right to reasonable bail, and you have the right to a preliminary hearing in the matter within 10 days. And you also have the right to force the state to prove each and every element of the offense charged beyond a reasonable doubt. So in CRA 25-621A, Mr. Frazier, it's alleged on or about October 2nd, 2025, you would operate a motor vehicle as defined in section 450101 of the revised code so as to willfully elude or flee a police officer after receiving a visible or audible signal from the police officer to bring the motor vehicle to a stop. The operation of the motor vehicle by the offender is approximate cause of serious physical harm to persons or property. That's an alleged violation of Ohio Revised Code 2921.331 BC 5AI, failure to comply with the order of a signal of a police officer. That's a felony of the 3rd degree. Maximum penalty on that is up to 3 years in prison and up to a $10,000 fine. In CRA 25-621B, it's alleged on or about October 2nd, 2025, you did knowingly obtain, possess, or use methamphetamine, Schedule II controlled substance in violation of Section 292511 AC1A of the Ohio Revised Code. That is aggravated possession of drugs, a felony of the 5th degree. Felonies of the 5th degree carry a maximum of up to 1 year in prison and up to a $2,500 fine. Do you have the money to hire an attorney?
No.
Are you working presently?
No.
All right, I'll appoint Attorney Sean Stratton to represent you. Mr. Hill, do you want to be heard on the matter of bond?
Yes, Your Honor. It's alleged that the attempt at a traffic stop turned into a chase on the highway at speeds of 80 miles an hour. So it's a pretty serious situation. We'd ask for a $7,500 cash assurance.
All right. I'll set bond at $7,500 cash as surety at this time. Mr. Frazier, your attorney's going to reach out to you at the jail, and he's going to speak with you. He can always have the matter, and I presume that he likely will have the matter recalled on bond.
And possession.
And so we'll take that back up here in just a few minutes after he's spoken with you.
I can't hear you.
Your attorney's going to reach out to you at the jail, and
Okay.
once he talks to you, he's going to have the matter recalled on the issue of bond, and then I'll hear arguments as to bond from you, but I need him to be able to speak with you first.
Okay.
So he'll have this recalled shortly.
State of Ohio versus Jaden Ferguson at the Lawrence County Jail, case number CRA 25382. Charles Howard on that.
All right, this is, well, let me get out.
Twice this morning. We just can't locate it. I'm not sure where it's at right now.
He's got all these charges still pending.
All right, Mr. Ferguson, can you hear us?
Yes, sir.
All right, this is State of Ohio versus Jaden Ferguson, CRA 25382. Mr. Stratton's case, he's asked for it to be recalled on the matter of bond.
Your Honor, so you said a $10,000 cash surety on this gentleman.
Correct.
Spoke with his family. It is only an F4 level felony. I asked for a lower cash surety on this. The court deems necessary. I think his family's going to work on posting the bond, but they need a lower bond, so.
Mr. Huber.
Your Honor, with the bondsman, the amount that they'd have to come up with is $1,000, and I think that under these circumstances, that the $10,000 bond that we requested is appropriate, and we'd ask the court to maintain that amount.
Okay. Well, this was a case that was filed in June. All right, I'm gonna amend the bond in this to 5,000 cash assured. So I cut the bond in half for you, Mr. Ferguson.
Yes, sir.
But I want a cash assurity bond on you, one that's at least sufficient to assure your appearance. Do you think Mr. Stratton is out of bond, do you think that he can make?
I believe I spoke to, I think it's his stepfather, so I believe that's one that they can make.
Okay. When do you want to come back for preliminary hearing then? Because if you think he can make the bond, we may be able to go out a little further, but if it's a situation where he can't make the bond, then I wouldn't want him just sitting without.
Yeah, let's go ahead and put it on for next Friday, the 10th. It's okay with the clerk.
That would be fine. All right, this matter's going to be set for preliminary hearing on October 10th at 10 a.m. So, Mr. Ferguson, if you make bond in your release, you have to be back here on October 10th at 10 a.m. If not, there'll be a warrant. And presumably, a bondsman's going to come track you down, and you're going to be back in jail, and I would imagine you're not going to get such a favorable bond the next time. You understand?
Yes, sir.
Okay.
May I ask a question real quick?
I don't know that you want to do that. You may want to ask that of your attorney, but
He can go ahead, Your Honor.
Okay.
It's on the general.
you may.
So what, did I miss court for the warrant get issued?
No, I don't think so.
I don't believe so.
No, there was not.
It was a warrant on complaint, Your Honor.
Okay. So when the state filed the complaint, they requested a warrant at that time, which they're eligible to do. So it was a warrant on the complaint. You didn't miss court. And so that's why that's part of the reason that I'm giving you, I cut the bond for you.
Thank you.
All right, thank you.
State of Ohio versus Charles Howard, the Lawrence County Jail, case number CRA 25620.
Okay, Mr. Howard, can you hear me?
Yes.
All right, this is State of Ohio versus Charles Howard, CRA 25620. It's Mr. Morford's case. He's asked for this matter to be recalled on the matter of bond. Mr. Morford.
Judge, we'd asked you for a similar reduction as the previous case. Mr. Howard feels that he can make a $5,000 bond. I've already been in touch with Mr. Sallards and told him that he was going to need a bond imminently as soon as you reconsider the matter.
Mr. Gill.
Your Honor, Mr. Howard said earlier that he had just gotten out of rehab. So, and I realize that our allegations today have not been proven. Understanding that, we still have concerns about whether he has substance abuse issues that still need to be addressed. We'd hate to have him released without some sort of supervision. So I don't know whether he maybe needs to be assessed to go back to treatment. Otherwise, we want the bond to remain as it is.
Mr. Morford.
Did you graduate from treatment, sir?
Last year I did. I went for detox for this year.
Do you have any substance issues at the present time?
No, sir. Only thing I smoke is weed, marijuana right now. I barely drink. That's about it.
All right, Mr. Howard, here's what I'm going to do. I'm going to give you the same opportunity that I gave another gentleman earlier.
Okay.
I'm going to ask that you be screened, urine screened down at the jail. I'll give you the opportunity right now, and I won't hold it against you.
Okay.
If you want to, if you're honest with me about anything that's in your system. And before you go any further, I'll give you the opportunity. If you're honest with me about what's in your system, then I would still intend to give you a favorable bond and potentially let you go back into treatment if it's something that would require treatment. If it's not, or you're not honest with me, then I'm probably not going to change your bond.
Okay.
So I'll give you that opportunity.
Okay.
Want to take the test? Mr. Howard, do you want to take the test?
Yes, I'll take the test.
Okay.
And what do you think is gonna be in your system?
If anything, probably be benzo, like colostrum or something.
Okay,
Cause I take grandma, I take psych meds too, so.
okay.
I
Well,
know that the marijuana would be in my system, that's about it, ain't nothing else.
okay, well, here's what we'll do. We're gonna have you screened and then we'll have you back out again here in shortly.
Okay.
All right, thank you.
State of Ohio recalls David Frazier to Lawrence County Jail, case number CRA 25619, CRA 25621, A and B.
All right, this is State of Ohio versus David Frazier, CRA 25619, CRA 25621, A and B.
Your Honor, I think we could set this for a prelim on the 10th. It doesn't matter what the bond is, he does have a holder out of Kentucky.
Okay. All right, Mr. Frazier, we're going to leave the bond the same because you've got a holder as it is, and so bond's kind of academic at this point. We're going to set this matter for preliminary hearing on October the 10th at 10 a.m.
Thank you.
Thank you.
Your Honor, we have recall at the jail.
There's one count.
No.
All right, we're going to have recalls at the jail shortly, but we're not ready for them yet, so we're going to proceed with the rest of the docket.
State of Ohio versus Tim Fortner, case number CRB 25301.
All right, this is State of Ohio versus Tim Fortner, CRB 25301. Tim Fortner. This is Mr. Morford's case set for pretrial. Mr. Fortner has not appeared here today.
Mr. Dickus? There.
Mr. Morford, any idea where your client is?
No, Judge, he is usually here. This is his first failure to appear that I'm aware of.
All right, well, I'll find that the time's now 11:47. He's failed to appear. There'll be a bench warrant to issue in 7 days.
Thank you, Judge.
Your Honor, if I may, this is the second time he's failed to appear for a pretrial.
That is correct.
Okay, I do see that on file. Well, I want the bench warrant to issue immediately then, if it's the second time. Looks like he was granted a continuance last time.
Thank you, Your Honor.
Thank you, Mr. Gill.
State of Ohio versus Amber Smith, case number CRA 24773, CRB 24774. Amber Smith.
Yes, sir.
All right, this is State of Ohio versus Amber Smith, CRA 24773, CRB 24774, CRB 22430. Mr. Morphe's case, it's set as pretrial and preliminary hearing. And Ms. Smith is available via Zoom today.
Your Honor, do you have a progress report dated September 7th?
I don't believe that I do.
Yes. Wonderful news.
All right, Ms. Smith, that's a very good report. Mr. Morford, when you want to come back?
Judge, a month or more, she's been at this for a while, it has always been clean and compliant.
Why don't we go out to November 21st, if you're here, Mr. Morford?
Yes, sir.
All right, November 21st at 10 a.m.
November 21st at 10 a.m.?
Yes.
All right, Sergeant.
Yes, ma'am, thank you.
Thank you.
State of Ohio versus Caleb Ross. Case number CRB 25-424.
This is State of Ohio versus Caleb Ross, CRB 25-424. It's Mr. Morford's case, subject to trial.
Change it.
Can you change it? Yeah.
I'll just do that.
Just sort of treatment and suspended jail, and if the court wanted to give him community service, we'd be okay with that too.
Your Honor, I believe we're going to have a change of plea today.
Okay. This is on the Walmart theft, it looks like.
Yes.
Okay.
We would enter a plea of no contest with the record stipulation of finding of facts for entering it with plea of guilty, finding of guilty.
Okay. Mr. Ross, is that correct?
Yes, sir.
All right. I will accept your no contest plea and I'll enter a guilty finding for the stipulation in the matter. It'll be 10 days jail, 10 days suspended, $100 fine, where you pay the court costs, 30 hours community service, level 4 probation for 2 years. You're going to be restrained from going in Walmarts, and you're going to be required to continue and complete your treatment at Southern Hope. I'm going to set your review date of April 10th of 2026 at 10 a.m. If you have everything completed by then you won't have to appear. So all your fines, all your court costs paid, all your community service done. Now, I don't know if you heard earlier, we have back-to-back Saturdays of double service. So if you did tomorrow and the following Saturday, you would just have 1 day left of community service. So you can knock all that out if you can do that.
Judge, would his review be at 9?
9 a.m., excuse me, you're correct. All right, Mr. Ross, you're going to need to meet with probation before you go, and then they'll set you up and you'll be free to go at that point.
Okay, thank you, sir.
Thank you, Your Honor. Good job, Judge. Good job.
State of Ohio recalls Amber Mills. Case number CRB 23621 and CRB 23556.
This is State of Ohio versus Amber Mills, Series 23621, Series 23556, Mr. Stratton's case. And we recalled this matter to determine whether or not there's another charge that has kind of cropped up here.
There is another charge. That charge is in Ironton Court, is not here.
Okay.
She has been arraigned on that charge, and Mr. Steyer represents her on that charge.
Okay, well, I don't know that I'm comfortable with ending the case here today until I kind of see what's going on with all of that. Have you been ordered into any type of treatment? Has she been ordered in any type of treatment out of that case at this point?
don't believe so.
It just happened. I don't go back till the 9th.
Okay.
Yes.
So next week?
Yeah.
Okay. All right, I'm going to set this out a little bit. Well, I don't get too far. Mr. Stratton, are you here on the 31st?
Yes, I can be, yes.
I'll set you back for August 31st,
Okay.
October.
or excuse me, October.
Thank you very much.
State of Ohio versus Jonathan Hall, case number CRB 25622. Separate waiting. Jonathan Hall.
Jonathan Ball. All right, this is case number CRB 25622. State of Ohio versus Jonathan Ball. Looks like Mr. Sowers is bonded then. Well, Mr. Ball was cited to be in court this morning at 9 a.m. The time is now 11:56. The failure to appear, bench warrants to issue. And I'm going to set a bond forfeiture for October 31st.
State of Ohio versus Paul Wiles, case number CRA 25354, A and B. Mr. Morford's case.
This is State of Ohio versus Paul Wild, CRE 25354 A and B. Mr. Morford's case set as a preliminary hearing.
You doing okay? Is he doing okay?
Oh my goodness, yes.
Close to graduation? Close to graduation?
No, he just came into services with
Oh,
us.
okay, I got you.
All right, it's a very good report. Mr. Morford, very good report.
Stay the course, Judge.
Okay.
He's just begun and needs some time.
All right, Mr. Morford, you here November 14th?
I am, Your Honor.
All right, we'll set this for preliminary hearing.
But no, Judge, I take that back. I have a trial in front of Judge Finley. That's day 2.
Okay, how about November 21st?
I'm here then.
All right, November 21st for preliminary hearing at 10 a.m.
Thank you, Your Honor.
Thank you.
Thanks, appreciate it.
Yeah, you're welcome.
Mr. Butch. State of Ohio versus Amy Dement here at the court, case number CRB 24363, CRB 24525, CRB 24526.
All right, this is State of Ohio versus Amy Dement, CRB 24363, CRB 24525, CRB 24526. Mr. President, for attorney, Mr. Morford, this matter is set for a trial. However, I believe that there's going to be a motion made.
May we approach, Your Honor?
You may. Good to see you, Mr. Ashford. You may. He requested from the court an interpreter, and we tried to get him here, but couldn't make that happen.
But I do want to point out this is like a fourth time. We've had some meetings issues each time. One of them does business and we've quite upset about having this work in the county and being told no go.
Well, this is, I'm not the one who said it for the times. The category set for this day, for the budget conflict, and I don't think it's lazy to have officers on vacation.
Why don't we do this? I think I got to make a decision on this, but rather than do it this second, if you're going to use this as an investigative time anyway, Butch still has a bunch of cases we'd like to hear. Why don't we go ahead and use that in case that maybe changes something? Okay, yeah, I wasn't sure if there was. Let's go ahead and argue it then. All right. Mr. Ashworth, my understanding is from pretrial bench, you're going to have a motion.
Yes, Your Honor. On behalf of the state, I would ask that this be continued to another date. The trial was set on this date on all three cases based upon a conflict that defense counsel had. The new date was picked when I was in a civil trial, and two of my officers are on vacation. One is actually out of the country. Despite that, I was attempting to make it work today because it has been rescheduled a few times, not because of the state every time, but it has been rescheduled a few times, and I've also issued subpoenas. Mr. Thacker, one of the victims in this case, has problems communicating. He's legally deaf. He recently requested a state-provided interpreter for the trial. So in addition to the fact that my officers are gone, that I didn't personally agree, although my office did, to this date, that it was reset at the request of defense counsel, and because one of the victims needs an interpreter, I'd ask that the court find good cause to continue this to another trial date. It does not need to be extensively into the future. It's a bench trial. It will take probably an hour and a half to 2 hours to try all three. I can do it on any Monday or Friday that the court picks from now until the end of the year, if you would grant my motion.
Okay, Mr. Morford.
Judge, I'm not unsympathetic to Mr. Ashworth's dilemma. However, this thing has been set 4 times. We've issued subpoenas 4 different times, one of them being to a business owner who is not real happy about coming down here and then being told, go back home, it's not happening today. We've been ready to go. I'd say I'm not unsympathetic to his dilemma, but we have been ready to go, and we've been ready to go 4 different times, Judge. We've issued 16 different subpoenas to have witnesses here in her defense.
Anything else?
No.
In response, Mr. Ashworth?
Again, Your Honor, the last time that this was set, I was ready to go. It was moved because defense counsel, not state, required additional time. And if we look back at the docket on this case, you'll find that the delays in this case are not solely, if ever, attributed to the state. And And we can brief that if you'd like. If there's a speedy trial issue, which I believe has been waived several times in this case because of delays not due to the state would love to try this case. But the fact that it was set for today, under these circumstances, with new developments, makes it not appropriate to be tried today. And all these victims just want their day in court. That's what I'm trying to provide to them. So that would be my response.
Okay. Well, Mr. Morford, I'm not unsympathetic to your plight either in this matter. However, this is a situation where it does appear from looking at the file that the continuances were primarily attributed to the defense in this matter. And we've got a situation where we've got a twofold problem. We've got a victim in this case. If this was a case where the state of Ohio was a victim, I would likely be denying this. But we've got, one, we got a victim, and two, we've got a victim alleged victim that is deaf and is, if they wish to have an interpreter, is afforded that opportunity by the law.
Understood.
That was requested, and the court made efforts to try to get an interpreter here today. However, an interpreter was not available to appear here today. And so I think based upon that, the safe thing would be to continue the trial reluctantly. But I think, based upon that, I think that there is a good cause for that. If it was simply that the officers were gone on vacation, I would not likely continue it. But where we have a situation where we've got a victim that can't communicate and would be allowed to have an interpreter by law, I think that my hands are pretty much tied whether I want to continue it or not in this matter. So I'm going to grant the continuance. Is there a date? Let's start with you, Mr. Ashworth. I know you said you're primarily available, but is there a date specifically that you're looking at or a range you're looking in, and then I'll get with you.
Based upon the representations of defense counsel, there's a business owner here who I'd like to talk to as well, frankly. If they want to provide information, I'm going to make myself available for whatever date Butch and these witnesses are most available. And if my calendar doesn't work for that, I'm going to move the other things.
Okay.
I think maybe the first concern would be when we could get an interpreter here to the Supreme Court.
Well,
Because I hate to set a date and then this happen again.
Well, I would think that if we go out into November, that would be sufficient amount of time to get an interpreter here.
Okay.
There wouldn't be any short notice on that.
What about November 7th? How's your docket look then?
There's 3 trials scheduled that day.
What was the date again?
7th. I don't believe the 7th would work.
The 3rd? Or you going to go later in the...
The 3rd would work if it works for really any other Monday and Friday currently, other than 28th, which will be after a holiday, so that the court would work in the month of November.
So I think Fridays, from my experience, are the best days to set these. So I would ask that it be, how about the 14th of November?
14th would work for the court's calendar.
I have a second day of trial in front of Judge Finley that day.
That's correct. 21st?
The 21st is good with me.
I can make that work.
Okay. All right, at state's request, I'm going to continue this to November 21st. It'll be a trial at noon, absent some form of true emergency. I would not anticipate any other continuance to be granted in this matter.
Agreed.
Agreed.
Thank you, Your Honor.
Thank you,
Mr.
Judge.
Ashworth. Thank you, Mr. Murphy.
If you're involved in this case, can you come up to the lobby, please?
State of Ohio recalls Hunter Tooley at the Lawrence County Jail.
All right, Mr. Tooley, can you hear me?
Yes, sir.
All right, well, you rolled the dice. This is State of Ohio versus Hunter Tooley, CRB 24385. It's Mr. Morford's case. We had you drug screened. You indicated that the only thing that would show up in your system was THC, correct?
Yes, sir.
Well, you were honest with me, and that's the only thing that showed up in your system. So to your credit, that is a good thing. All right. How many days have you spent in jail?
30.
All right. Here's what I'm going to do.
Do you want to say anything?
I'm going to start with you, Mr. Morford, on matter of bond.
Judge, I believe he lives with his grandmother who is seated directly behind me, and I believe she's ready for him to be at home. Although I'm not sure if he's in inpatient treatment at the present time or not.
Mr. Tooley, when's the last time you were in treatment?
7 months ago.
Okay. Mr. Hill, arguments to state, we have the only thing that showed up was THC. He was honest about it, and he says he hadn't been in treatment in 7 months, so.
And that's good news. Now, I know the court already knows that we've got a string of charges that we have extended and extended and extended the opportunity for Mr. Tooley to get things right. And part of the reason why is because some of these charges involve family members, I believe his mother, who wants him to do better, understandably. But I think that it's appropriate to reconcile these things and to, if he wants another chance, it ought to be as part of his probation. Now, he's already pled guilty to one charge, 23 CRB 147, aggravated menacing. That's not been sentenced.
Okay.
He's got 24 CRB 292 domestic violence pending. He's got a burglary charge pending in 24 328. And he's got a criminal mischief pending in 385A and paraphernalia in 385B. And we would be okay with him receiving a suspended jail sentence and credit for how many days he's been in here. We would nollie the burglary charge without prejudice and have him plead to the remaining charges, and so he could get out and go to treatment today, but we'd want 6 months in jail suspended. Otherwise, I mean, we can keep extending him the opportunities, but if he doesn't follow up on it, then it's not fair to just write it off and say, well, we're not going to worry about it. Either that or we can have trials if we need to. I'd prefer that him not have to sit in jail waiting for a trial to happen.
Okay. Mr. Morford, you've heard from Mr. Hill now.
Judge, he still has cases pending here today, and what he's in jail for is a failure to appear. He was honest with you with what would be in his system. We'd ask that he be released on the OR bond.
Okay. All right, so here's what I'm going to do, Mr. Tooley. I am a man of my word, and you were honest with me. But here's what I'm going to do. I'm going to put you on a real short leash. So I'm going to have you go ahead and have you back on Monday. Okay? So October 6th at 10 a.m. for pretrial and preliminary hearing on all cases. Because the only thing in your system was marijuana today, I'm going to give you, or I'm going to sentence you on the failure to appear. You said you were in 3 days?
Yes, sir.
I'll sentence you to 3 days, give you 3 days credit for that. And I will release you on a $5,000 OR bond. Now, if you don't show up Monday, or you show up and there's anything in your system other than, I'll go ahead and tell you, I'm going to screen you Monday. If you show up and there's anything else in your system on Monday, that bond's going to get revoked, and you're probably headed right back where you are now. Okay?
Yes, sir.
All right. Well, what we're going to do is, we're going to either on Monday, we're either going to find a way, figure out a way to resolve these cases on Monday, or they're all going to get set for trials.
And we might even send the felony burglary to the grand jury.
And that is the case, Mr. Cooley, the state has a felony burglary charge, and they certainly have the right to either dismiss it and take it straight to the grand jury, or they can say, hey, we're going to take it. You can either waive or don't waive on it. So there's going to be some incentive there, and they may have a pretty strong bargaining chip with you. That's between them and your attorney. But we're going to work on getting this case resolved one way or another on Monday, whether it's through, we're going to set it for trials, or through some form of agreement. Okay?
Yes, sir.
All right, so I'll see you back Monday at 10 a.m.
Yes, sir.
State of Ohio versus Charles Howard, Lawrence County Jail on recall.
Thank you, Judge.
All right, Mr. Howard, can you hear me?
Yes, Your Honor, I wanted to also let you know, I'm in aftercare at OVP over in Parkersville too.
Okay, well, hang tight just a second. It's the State of Ohio versus Charles Howard, CRA 25620. Mr. Morford's case, we're recalling this matter on bond. So, Mr. Howard, I gave you the option on I gave you the option on this to screen and to be honest with me, and you rolled the dice on it. And I've got your screen in front of me, and you were honest with me. The only thing that showed up was THC in your system. So because of that, I think, Mr. Morford, you want to be heard on the matter of bond, I presume?
Yes, Judge, we'd ask you to reduce it by 1/2. He believes that he's able to afford that, and I've already notified Mr. Sallards that he's going to need a bond when you set it.
All right. All right, Mr. Howard, since you were honest with me on your screen, and your screen came back good, I'm going to set you a bond at $5,000 cash as surety. I'm going to order that you continue your aftercare, and it's an OVP in Proctorville?
Yes, yes, sir.
Okay. I'm going to order you to bring a copy of that with you to your next hearing.
Okay,
That shows you're there and how you're progressing.
okay.
All right. Mr. Morford, when do you want to set a preliminary hearing in this, if you believe he's going to make the bond?
What about Friday, Judge, just to make sure,
Okay.
because I'd hate for him to be sitting and not make bond.
All right, I'm going to set this for preliminary hearing October 10th at 10 a.m. All right, Mr. Howard, your next hearing is next Friday, October 10th at 10 a.m. If you're not here at that point, the bondsman's going to come find you, and you're going to end up back where you're at, and your bond's not going to be so favorable.
I know.
All right, so we'll see you back at that time.
Okay.
All right, thank you.
Thank you, Your Honor.
Thank you, Judge.
Thank you, Mr. Morford.
State of Ohio versus Dixie Griffith, here at the court, case number CRB 2388.
All right, this is State of Ohio versus Dixie Griffith, CRB 2388. It's not a set of the sentencing, it's, I think, Mr. Holt's case, but my understanding is he'll be here today. Congratulations on the job.
Thank you.
All right, that was a very good report, Ms. Griffith.
Thank you.
You've got a job, you've got a plan, which is important. You've got something to work towards. So, and you've done so well that I'm going to set this back a little bit later so you're not going to come back as often on this one.
Okay.
So I'm going to set you back for November 24th.
Yes, sir.
It'll be a sentencing hearing at 10 a.m.
Okay.
Keep up the good work.
Thank you, Your Honor.
Thank you.
Have a blessed day.
You too.
State of Ohio versus Kirsten Shipman, case number CRB 23698. Set for sentencing. Kirsten Shipman.
All right, this is State of Ohio versus Kirsten Shipman, CRB 23698. This is Mr. Morford's case, set as a sentencing hearing.
It's Kirsten. Yeah.
Everything good?
Yeah. Okay, I'll give her. I'm not focused. Oh, my God. Take this, these spots.
Mr. Morford?
Judge, I'd like to continue on. She's doing well at Focus, it appears.
She's just getting started, it looks like.
Yes,
I can
Judge.
tell. And now, I don't, I'm not encouraged by what was in your system, but you're just getting started. So we would expect those things to go out of your system, and we're glad that you are seeking treatment. The things that you're taking can kill you at any time, and nobody wants to see that. So I don't want to go too far out on this, because I want to make sure that you are continuing in your treatment and you're continuing to do what you're ordered to do. Mr. Morphy, are you here October 17th?
Yes, Judge, I am.
All right, I'm going to set this 2 weeks out, October 17th. That'll be a sentencing hearing.
Thank you, Your Honor.
Thank you.
State of Ohio versus Austin Pritchard, case number CRA 18-1233, A and B, CRB 18-1234, A and B, CRC 18-3525, A and B.
This is State of Ohio, this is Austin Pritchard, CRA 18-1233 A and B, CRB 18-1234 A and B, CRA 18-1233 A and B, CRB 18-1230. Okay. Matter says sentencing, it's Mr. Morford's case. Mr. Morford.
Judge, I believe he's here for sentencing today. He's been making payments on his court costs and fines, or restitution, rather, in some older cases. And he's done what's asked of him.
Well, let's continue on. I think he's quite ready to be done with these, but let's continue on here. So let's go out. Mr. Morford, you're here on November 7th, correct?
Yes, Judge.
All right, let's do November 7th. So it's sentencing hearing at 10 a.m.
Thank you. Thank you, Your Honor.
Thank you, Mr. Morford.
State of Ohio versus Belinda Fuller, CRB 24-624 and CRB 21-753.
State of Ohio versus Belinda Fuller, CRB 24-624, CRB 21-753. This is Mr. Stratton's case. This matter is set as a sentencing hearing.
Yes, Your Honor. Earlier this week, we got Belinda out of jail, and all of her amended reads, and I believe everything's going okay so
Yeah,
far.
we had her just a little while, but I dealt with her yesterday, and she seemed really good-spirited and wanting to do the program as we suggest.
Completed. Yes.
Ms. Fuller, I will tell you this, you look a whole lot better than the last time I saw you.
Thank you.
So it seems that whatever you're doing, at least at this point, is beginning to work. So we'll keep you right where you are. And
Oh, yeah. I like being there.
We'll continue on. Mr. Stratton, are you here you're here on November 7th?
Yes.
Let's go to November 7th for sentencing.
Okay, thank you,
You're
sir.
doing what you're doing.
Yes, sir, I will.
State of Ohio versus Brianna Morgan, case number CRB 22-801.
All right, this is State of Ohio versus Brianna Morgan, CRB 22-801. All right, Ms. Morgan is present. We had remanded her into custody this morning after some conversation with the court on the review and her lack of efforts of community service. Now, Ms. Morgan, I want you to look at me. I certainly understand your plight and some things that have gone on in your life that has caused you some hardship. That is not lost on me. But, that being said, this case is from 2022, it's 3 years old, and bad things happen to everyone. Everybody has hardships, and you have two opportunities. You can either sit and say, okay, I'm going to be the victim in this situation, or I can dig myself out of my hole. And part of digging yourself out of the hole is going to be getting these things done. So, that being said, and I know your hardships, some of them that have come up, but I'm going to give you another opportunity with this, but it's going to be, there's going to be a stipulation to this, and you're going to have to figure it out. So we have double duty 2 weekends in a row on community service, tomorrow and the following Saturday. I'm going to order you to do both. If you don't, if we come back and Mr. Cooper says that didn't happen, then you're going to tie my hands with that. But in doing both of those, I mean, you're going to cut you're down to half, just right there in 2 days. And so we'll do that. So I'm going to release you from custody, and I'm going to put you back on for review on October 24th. Because I believe I'm here that day. It's going to be a review at 9 a.m. Get those days done, you'll be down to half, and then a few more days after that, and you're done.
Your Honor, if I may, I believe she's on for sentence. She has a bond up to 2 hours.
Okay. All right. Okay, it'll be a 17-minute at 10 a.m. So just try to get this done as quickly as you can, Ms. Morgan. And I know it's not fun coming here. It's even less fun sitting in the back. get it done, get this behind you. All right, thank you, Mr. Moore.
State of Ohio versus Carrie Beth McCoy, case number CRB 24227. She's also.
What's this one? Oh,
All right, this is State of Ohio versus Carrie Beth McCoy, CRB 24227. And CRB, yeah, okay, this is CRB 24227. Ms. McCoy remained in the custody this morning. There was, apparently, Ms. McCoy has been to a significant number of treatment providers over the course of this, and my understanding is she was told that that was her last opportunity. Now, my understanding is she was discharged from where she was most recently at Focus, but she is already in somewhere else. So I guess the question I would have is, what was the circumstances of that discharge? And this is Mr. Morford's case. Mr. Morford, this is Carrie Beth McCoy. She was discharged from treatment and I believe was in a new treatment facility.
I'm so sorry. I'm so sorry.
You got a report of it.
I only had the two I gave them.
He got discharged.
And once I read through this, Mr. Morford, I'll let you read it as well. Or Mr. Morford, if you want to approach, there's another copy here. Mr. Morford, if you want to approach, there's another copy here for you to review.
Thank you, Your Honor.
No problem. Actually, here, let's do this. Let's recall this again. I will give Mr. Murphy an opportunity to speak with her as well.
Excuse me, Mr. Morford. Mr. Morford, we're about to call your trial. State of Ohio versus Aaron Freeman. Case number CRB 25318, CRB 25174.
State of Ohio versus Aaron Freeman, CRB 25318, CRB 25174. This matter is set for a trial.
Did you complete it? He completed it, Mr. Hill. Do you have a certificate to that effect?
They should have it printed out.
I'm sorry?
They should have a copy here. I gave it to them like 2 months ago. I brought it to you before.
I have a copy of it.
Good. This is,
For completing family
Okay.
anger.
Your Honor, if I may,
May.
to please the court, we have the two young ladies that are the alleged victims in this matter, and we take this very seriously. Just so that the court understands where we've been on this, we had originally agreed for Mr. Freeman to attend to anger issues and complete anger management counseling, and we were considering dismissals of the charges, or at least a better treatment of the cases if he did that. And we kind of hit a snag about, I don't know, a month or so ago, and Judge Capper was not happy with the state of things and the lack of progress by Mr. Freeman as far as doing what he said he would do. And so it was these were set for trials today. And after speaking with Mr. Morford and after him speaking with his client, they've decided, I believe, that he's going to plead guilty to the charges. They've also given us a certificate showing that he's completed anger management counseling. And so we're satisfied with that part of it.
Do I have a copy of the certificate in the file?
We do want Mr. Freeman to know that this behavior, and I've got deputies here who've dealt with him, it's got to stop forever. It's got to stop. And hopefully the anger management counseling has taught him some things about his own. He's got to control himself as far as his behavior. He also needs to leave these two women alone. Now, he's got children with both of them, and there are ways to get visitation instead of arguing and threatening and things of that nature. What you do is you go to the court, you verify that you are the father, you ask for visitation, and the court gives you visitation, and you follow those orders. That's the way you do it. It needs to be done in both. We're not recommending that as an order of this court, but that's got to happen for peace. These children need peace. The mothers need peace. And so we're expecting that. Our recommendation on this is 30 days in jail, suspended. He's completed anger management, 2 years probation. We're not concerned about whether it's ongoing to be reporting or not. But we do want no contact orders in both of these cases. And we want the probation to continue on for the full 2 years.
Mr. Morford?
Your Honor, I believe we're going to have to change the plea to guilty, Your Honor, in anticipation, consideration of the state's recommended sentence. Mr. Freeman, I believe, now understands that he can't resort to self-help when it comes to visitation and that he needs to go through the court system. If he's having trouble seeing his children, there have been no further incidents that I'm aware of, and we'd ask you to accept this as a joint recommended sentence.
Okay, is that correct, Mr. Freeman?
Yes, Your Honor.
And that's in both cases?
Yes.
All right, I'll accept your guilty plea and our guilty finding. On the 25-318, I'll order 30 days in jail. I'll suspend all 30 of them. You completed your anger management. I'll make a note of that. There's going to be a no contact order in favor of Caitlin Edwards, Kaytel. It's spelled wrong, I'm fairly certain.
Kaytelyn.
Okay, there's a second N in there.
Yeah, there's two.
There's two N's?
There's two N's at the end, yeah.
Oh, maybe it's not spelled correctly.
It's like Kate Lynn,
Yeah,
Katelyn.
So there's a Y?
it's Kaytelyn.
L-Y-N-N. Okay, there was no Y in the document. But that's going to be subject to any further orders of the common police court. So if there's, the no contact order is in effect out of the probation here. However, if the domestic relations court orders you to have contact through an app or something of that nature, our order is going to be subject to their order. So I want that in there. It'd be a $50 fine, and I'll order you to pay the court costs on that, and 2 years under field probation.
What is it now? What did he say?
You'll come to the meeting with me and probation. You'll get a copy of everything.
And there's going to be a review hearing on that for April 10th of 2026.
Just, okay, thank you.
That's at 9.
On the CRB 25174, order 30 days jail, 30 days suspended, order court cost, $50 fine. Review date, April 10th, same day, 2026 at 9 a.m. There's going to be a no contact order in favor of Audrey Westmoreland. I'll note that he's completed anger management on this. 2 years level 4 probation.
April 10th. It's just one hearing.
All right, Mr. Freeman, you're going to need to see probation before you go. They'll take care of you the rest of the way out from here, but you can't have any contact with them. But if you go to the domestic relations court, you file, and the court says you have contact, but through an app, or it can only be about the kids, or whatever it may be, and they specify it in a manner, that will not violate our order.
You said that's called what now? Domestic what?
Relations court.
Relations.
At the common police court.
Okay.
So if there's an order out of there, our order, our no contact order is going to be subject to their order. So their order is going to supersede that. It doesn't do away with it, but if the court says, hey, you know, there's got to be contact about the kids, then we're going to go with that here as well. And likewise, I want you guys to understand that that's typically how that's done. If he doesn't do that, then there is no contact whatsoever. So that could be up to him. Or if the court down there says there should be no contact whatsoever, then that's part of their order, and all of their abides by that as well.
Thank you.
All right, Mr.
Thank you,
Freeman,
Your Honor.
let's see the probation card.
Thank you.
I'll give you a few minutes, Mr. Morford, to talk, and then I think I'm going to see that. I'm going to give him, let him see your report as well. I think he's seen it. All right, we're going to be, this is our last case. We're going to be in a brief recess until we come back.